Hi, my name is Schyler Church. I am a California real estate broker as well as a member of the education department at Accredited Real Estate Schools. We offer the course requirements to be eligible to take the state exam and receive your real estate license in California, but also a multitude of options to help you prepare for the state test. One of the tools that we use is practice questions. We have a program that is 3,600 questions, and I have that link below if you'd like more questions. This is just a few questions to help you prepare and give you an idea of how well you're doing in your studies. So let's dive into it. 1. A deed of trust is recorded in 2006. A mechanic's lien is recorded in 2020. Which has priority? A. The deed of trust has priority because it was recorded first. B, the mechanic's lien has priority because it is not required to be recorded to be valid. C, the deed of trust has priority as long as work was started and or materials were delivered after the deed of trust was recorded. D, the mechanic's lien always has priority over deeds of trust. As always, we like to go through the question, dissect it, understand what it's asking to kind of give us an idea of and formulate an answer before dissecting and going in depth over the answer options. This will guide us in the right direction. So the question is talking about priority of recording. And we have a deed of trust that's recorded in 2006. Mechanic's lien is recorded in 2020. Well, normally, as you should be thinking of the rule, first to record is first in right. However, there are 3 exceptions when it comes to mechanic's liens, taxes, and subordinated loans. So those 3 exceptions we need to take into account for the rule, first to record is first and right. So mechanic's lien is saying that this one is recorded in 2020. Well, the deed of trust is recorded in 2006. So normally we would think that the first to record of the deed of trust has priority, but mechanic's lien is an exception. Even though it was recorded in 2020, it could have priority over the deed of trust if work was started prior to the recording of the deed of trust or materials were delivered before the deed of trust. So knowing all of this, which one would be the best answer? Well, A, the deed of trust has priority because it was recorded first. So yes, this is a good answer that the deed of trust does have priority, but it's not just because it was recorded first, because we have to think of that for the rule, first to record is first and right with those 3 exceptions. So that's a good answer, but it's not really the true reasoning why that the deed of trust has priority. B, the mechanic's lien has priority because it is not required to be recorded to be valid. No, a mechanic's lien does need to be recorded to be valid. We do know that. C, the deed of trust has priority as long as work was started and or materials were delivered after the deed of trust was recorded. That's good. That's saying, hey, that the deed of trust does have priority. We do know that. That is true. But the reason why is because that the work was started or materials were delivered after the deed of trust was recorded. If it was done prior to the deed of trust being recorded, then the exception of the rule of that mechanic's lien that we've been talking about would have priority. The mechanic's lien always has priority over deeds of trust. No, mechanic's liens do have priority with those 3 exceptions that we were talking about, mechanic's liens, taxes, and subordinated loans, but it depends on when materials were delivered and or that work was started. So really important to know. Now I kind of want to go into this a little bit more here. So the correct answer is C. Now why is this the correct answer? We've already talked about it quite a bit, but I want to go over a little bit more explanation so you have some information on it. So the rule is first to record is first and right with 3 exceptions: mechanic's liens, taxes, and subordinated loans. So mechanic's lien takes priority when materials are delivered and or work is started on the property. So in this particular question, a deed of trust was recorded in 2006 and mechanic's lien was recorded in 2020. Since the deed of trust was recorded 5 years earlier, it would indicate that it was in position long before work was started on the property. A lot of times, mechanic's liens would happen within about a year because of permits and their expirations. So this was clearly a lot longer, the deed of trust between the mechanic's liens being recorded. So it indicates that work would have been started on the property way after the deed of trust was recorded, but we can't guarantee it. So based on the question of what it was saying, that it did say on there that the deed of trust would have priority over the recorded mechanics lien, as long though as work was started and or materials delivered after recording of the deed of trust or recordation of the deed of trust. So important to know, keep this in mind, and I hope it was helpful. And let's dive into question number 2. 2, can an unlicensed person sell a property and collect a commission? A, yes, if he or she is acting as an attorney in fact. B, yes, as long as the commission is equal to the amount of money needed to cover expenses that were only sale related. C, yes, as long as the unlicensed person is enrolled in a real estate course. D, yes, as long as it is a commercial property. So let's dissect the question and also understand the answer options here. So the answer options are all saying yes. What explanation would be the only reason an unlicensed person could sell a property and collect a commission? Well, as you know, if you are aware of real estate agency and with the real estate license law of what an unlicensed person can do versus licensed, an unlicensed person is limited on pretty much anything when it comes to an agency relationship. You cannot represent someone and sell their property and collect a commission unless you're representing yourself as a principal. So, for instance, a FSBO, for sale by owner, you can sell a property on your own. Now, a thing here, though, is you could collect a commission, though, where it's kind of like you're selling it as a FSBO, but you're actually an attorney in fact for the seller. So let's say seller Abel is selling their home, and they have this person named Charlie. They have a trusted relationship, and so Abel gives an attorney in fact relationship to Charlie. So Charlie has power of attorney to Abel. It could be a limited power attorney, general power of attorney, depending on it. But let's say it's a limited one and Abel to sell this house and collect a commission for doing so on behalf of Abel. And that is something you can do because, remember, power of attorney, you have the ability to actually sign as that person and act on their behalf. Whereas as an agent, so us as a real estate agent, we do not have an attorney in fact relationship with our principals. We have an agency relationship that allows us to have a fiduciary relationship or an honest and fair dealing relationship with other third parties, but we cannot sign on behalf of our principal. That is something we are not able to do. We cannot make decisions for our principal. But an attorney in fact relationship is something that could be given to someone, and if so, they could sell a property and collect a commission. That is the only reason that an unlicensed person could do it. It doesn't matter if the commission is equal to the amount of the money needed to cover the expenses. If you do not have a real estate license and you do not have the power to actually sell the property yourself, you cannot sell the property and collect a commission. Very important to know that. And it doesn't matter if you're getting your real estate license and doing the coursework, you have to have an active real estate license. And as long as it is a commercial property, doesn't matter what type of property. In California, the only explanation or the only exception to this rule is an unlicensed person can sell a property and collect a commission if he or she is acting as an attorney in fact. So A is the correct answer. And really make sure, important to understand agency relationships versus the power of attorney in fact relationships that someone could have. Because us as a real estate licensee, we have an agency relationship with our principals, whereas you could, if maybe you could have a power of attorney and an attorney in fact relationship if you're very well known to the person and they trust you and want to give you that power. But that is very, very rare. 3, which of the following is an open planning design with simplicity, horizontal lines, easy access outside, window panes, and new construction? A, Colonial, B, Ranch, C, Monterey, D, Contemporary. Well, you might be asking, why are we talking about this? Well, this is something you actually need to know for the state exam. I think it's a relatively trivial question, but you do need to know about it because it is something within the 7 areas and on the outline that the state exam uses to pull their state exam questions. And this is one that you could easily see. So on this, we're talking about a type of design. So what style is simplistic, horizontal lines, very modern they're kind of getting at here, easy access outside, large windows, so lots of windows, and relatively new construction, so more modern. On that case, the correct answer out of all of these is contemporary. You kind of just need to know that when they're referring to this, it is contemporary. Colonial, Ranch, Monterey, very distinct types of styles. And the one, though, for contemporary is more modern, simplistic, for very outside-driven, large windows, lights, newer homes. That is the kind of what the key terms you need to know for when it comes to contemporary style, when it comes to architecture and homes. So contemporary. 4, how long are restrictions valid? A, 10 years, B, 50 years, C, until the property is conveyed, D, perpetual. Well, you need to know what perpetual means. So perpetual means forever. So it's in perpetuity, and that just means it continues on. So restrictions, we're talking about type of restrictions that you might have. So like deed restrictions, how long are they valid? Well, when they're in the deed, they are valid forever. They don't expire unless they're amended or changed, for instance, and that has to be in writing, and everybody has to agree to that for it. So restrictions are good forever. And knowing that, the correct one would then be perpetual. Perpetual. Doesn't matter once for 10 years, 50 years, it continues on and it continues to the new buyers, other buyers. So even if the property is conveyed, it continues those restrictions to those new buyers or that new buyer. So perpetual. So again, the state exam is kind of like a reading comprehension exam as well. 5, accretion is A, the rapid tearing away of the land, B, constructive severance, C, the gradual buildup of alluvium along a riverbank, D, under the doctrine of appropriation. Well, let's first understand what accretion is. So accretion falls under a cession. So remember, a cession is a way of gaining land, and it's by actually gaining of land either through annexation or accretion. Annexation is by man-made, so physically joining maybe two parcels of property, or accretion, which is the gradual buildup of soil along a water bank, so like a riverbank. So that is accretion. Now, going through these answer options, let's see which one fits best. So accretion is not the rapid tearing away of the land. That is called avulsion. Constructive severance. Well, the word sever is in there, and sever means cut, for instance. So that would not be the case because you're not gaining land. You're actually usually changing the property from real property to personal property. The gradual buildup of alluvium along a riverbank, yes, because I was talking about the gradual buildup of soil along a riverbank, and soil is, so alluvium is basically the soil, the dirt, those brown particles floating along the river that actually attaches to the riverbank and creates this gradual buildup of land. So that looks to be the correct answer. And then D, under the Doctrine of Appropriation, no. Appropriation, we know, deals with landowners that are wanting to gain access to use land or use water, even though it's not next to their parcel of property, but they're near a body of water. So then they would go for a Doctrine of Appropriation to obtain that right because they don't have riparian water rights. So the correct answer is C, the gradual buildup of alluvium along a riverbank. That is accretion. Thank you so much for watching. I hope this was helpful. Make sure to check out our website at accreditedschools.com. We have a ton of exam prep options, a lot of courses, and to assist you with obtaining your real estate license. And if you've already done the courses and you're just studying, we also sell exam preparation strictly for the state test all by itself. And just know we only focus in California. That's all we do, and we only do for your real estate license. So either salesperson or broker. This is just a few questions. I hope it was help, and feel free to contact us if you have any questions as well. I'm Schyler with Accredited Real Estate Schools. Thanks for watching, and good luck with your licensing journey.